Welcome everybody to the last and best session of the whole conference. We're excited to consider this topic with two great scholars in the field. My name is James Toronto, and I'll be chairing this particular session. I'm excited about it because I lived for several years in Saudi Arabia and Egypt and Turkey, Jordan, and I came away from that experience in long, deep discussions with Muslim friends. Number one, how much Muslims care about Sharia, how interwoven in their lives it is, but at the same time, how deeply and widely they disagree from country to country on how to interpret it, how to apply it. And so it's a little bit confusing, and I think that's one of the reasons we wanted to have a panel on this. Debates surrounding the nature and role of Sharia have intensified in recent decades. Within the Muslim community, there's a long-standing tension between moderates and conservatives concerning the definition of Sharia and the extent to which traditional legal methodologies and rulings can be adapted to an evolving contemporary secular context. We've already touched on that theme in a number of the presentations, but we'll get to go deeper this time. Outside the Ummah, which is the word for the Muslim community that the Muslims like to use, the notion of creeping Sharia, which is a term that's emerged in sort of right-wing politics here in the United States, as an existential threat to the norms of North American civil society, has gained widespread currency among political conservatives. The purpose of this panel is to clarify and explore these issues in terms of both intra-Muslim dynamics and external relations with non-Muslim interlocutors, institutions, and communities. It's my great pleasure to introduce our two presenters today, our two speakers. Natana DeLong-Ba is Associate Professor of the Practice and the Theology Department of Boston College. Her research focuses on Saudi Arabia and the Gulf countries, especially Islamic politics, contemporary jihadism, and women and gender issues. She is president of the American Council for the Study of Islamic Societies and editor-in-chief of the Oxford Encyclopedia of Islam and Women. Her book, Wahhabi Islam, From Revival and Reform to Global Jihad, was named one of the 5 best books for understanding Islam by the Wall Street Journal. We also have the honor to hear from Professor Asifa Qureshi-Landis, Professor of Law at University of Wisconsin Law School, where she specializes in comparative Islamic and U.S. constitutional law. She was awarded a 2012 Guggenheim Fellowship for her work on Islamic constitutionalism for the 21st century. Her recent publications include articles on comparative legal theory, Islamic criminal law, and Muslim family law in U.S. courts. She has served as a public delegate on the U.S. delegation to the UN Commission on the Status of Women and as advisor to the Pew Force on Religion and Public Life, among many other organizations. So without further ado, we'd like to give Professor DeLong-Ba and Professor Qureshi-Landis the full 30 minutes that they need, and then we'll have some discussion. So would you... oh, I'm sorry, I was looking over there. I apologize. Go ahead.
Thank you, and I'm hoping that my slides will come up in just a moment. But I'd like to begin by thanking all of the organizers, especially Grant Underwood, and everyone who has worked so hard to make this event not simply a conference, but really a shared living experience that is, from my perspective, has been the hallmark of which has really been hospitality and friendship. So thanks to all of you who've made this such a wonderful experience. The goal of this particular lecture is to cover some of the common stereotypes and fears of Sharia, particularly in the American context. Many of us, when we hear the word Sharia, we probably have some kind of scary image that comes to mind. And I think that's particularly the case following the withdrawal of US troops from Afghanistan and watching the resurgence of the Taliban and Al-Qaeda there. And so what I hope to do today is to provide us with a framework for understanding what Sharia is, what Muslims mean when they talk about Sharia, what aspects of Sharia, if any, Muslims would like to see implemented in the public sphere, and also what aspects they might not. And then also to think about what Muslim debates about Sharia share in common with other debates about religious values in public life, particularly among Christians. And I hope that by doing that, you will leave this panel with more accurate information about and understanding of Sharia, and hopefully less fear. So, as is my habit, I like to take the issues head on. And so when I was trying to think about all of the fear factors that combine into this, especially in this American context, and a number of our speakers have talked about this, that there's this range of fear from Muslims seeking to overthrow American values or overthrow the Constitution, fear of relegation of women and religious minorities to second-class citizenship. And I'll just pause here to note that 8 out of the 14 speakers at this conference have been women. So the idea of Islam is oppressive to women, perhaps we've started to shatter that stereotype just through this conference. There's also a fear of immigrants and darker-skinned persons, and this idea that there are certain persons who refuse to integrate into American society and perhaps reproduce at a higher pace than native populations, however that's defined. And so these combined fears of loss of native identity, culture, and civilization, and this idea of a threat from within and radicalization and acts of mass violence, I'd just like to note are also often paralleled by fears within the Muslim community of rising xenophobia, racism, and hate crimes, of which we continue to see, sadly, far too many, as a number of our speakers have noted. According to the FBI, there were 176 such crimes in 2019 alone. That's the most recent year for which statistics are available. We live in a time of fake news, alternative facts, and sensationalist headlines and hype generated by interest groups, lobbies, and politicians alike. So, in as much as factual information can sometimes be limited in its usefulness, I do think it's important to have some factual information for framing our discussion. And as many other speakers have done, I'll be drawing from polls and surveys, largely from the Pew Research Center and the Southern Poverty Law Center. In terms of demographic concerns, you might note that even though there's this concern about a demographic explosion leading to Muslim dominance and Islamization of countries, the reality is that in the United States, only about 1% of the US population is Muslim. It is expected to double by the year 2050, but that's to a whopping 2%. If we look at the distribution of immigrants to the United States, what we see is that they do not all come from the Middle East or the Muslim world. We actually have a fairly even split across regions. There's not some sort of massive influx of foreign Muslims coming into the United States. 4 out of 10 Muslim American adults are white, and we have a breakdown here of foreign-born, US-born, second and third generation. One thing I would point to that ties into Professor Jackson's talk on Monday is that 51% of third generation or more American Muslims are actually Black, and so restoring those voices to this broader conversation is important. In terms of numbers of children, Muslims have an average of 2.4 children. It's slightly higher than the overall average for the US population of 2.1. And so ultimately, I think my point here is that these kinds of demographic concerns that we hear raised by certain parties don't really seem to have much of a basis in reality. Even if we turn to the case of Europe, we find that Muslims overall still constitute less than 5% of the total population. And even if we are looking at numbers of recent refugees to Europe, they only account for about half of all immigrants to Europe. So it seems that our fears oftentimes are far more expansive than the numbers would support. There have been questions about how much that population is going to grow in the years to come, and this particular graph shows 3 possible scenarios depending on a variety of circumstances that could affect future migration patterns. The worst case scenario shows that the migrant population might grow to about 14% of the total population by the year 2050. That's still a significant minority and would be much less, far lower than Christians or non-religious persons. And so I hope that looking at some of those statistics helps to lay to rest certain fears about being overtaken or overwhelmed by Muslims. So, what exactly is Sharia? Jack had mentioned earlier that the Sunnah is something you can't go to the library and check out as a book, and the same thing is true of the Sharia. The term, as Hadia pointed us to, means a path to water, and I just want to think about that phrasing for a moment. This idea, path to water, water in Scripture, whether we're talking about the Quran or the Bible, always symbolizes the divine presence. And so the purpose of the Sharia is to serve as this path to water, this path that leads us to God. And another point I would like to make with respect to water is that you can't really pick it up and hold it in your hand. The point of water is that it is intended to be fluid and that it needs to move in order to remain a source of benefit. If you've ever watched animals, you'll notice that they don't drink from stagnant water because they know instinctively that diseases can proliferate in stagnant water. And so I think the idea of Sharia as a path to water encourages us to think about something that is intended to be dynamic and fluid so that it can be life-giving. When we try to define what exactly Sharia is, there are many scholars today who point to the idea of maqasid of Sharia, this idea that it refers to broad objectives or values that the law is supposed to fulfill. And so we have this ethical code that provides guidance in many different directions for social, educational, cultural, economic, and political practices for the Muslim community. Sharia is supposed to provide us with a common code for behavior. It's sometimes phrased as simply as promoting good and preventing evil, which is very open to interpretation. And it refers to matters related to both worship and human interactions. Sharia includes values such as good governance, individual accountability, the provision of social justice, assurance of a fair marketplace, care for the poor and marginalized with special attention to orphans and widows, the provision of public safety and security, the protection of life, bodily integrity, and private property, freedom of religious conscience, attention to the common good, maslaha, which is often described as public welfare or the public interest. And you'll note that the connecting point here is that all of these are intended to work together to build and maintain strong and connected communities, not just through the assertion of rights, but also through the fulfillment of duties. So this isn't something that you just take. It is also something that you have a responsibility to give back with. And this is true at the individual level, the community level, and as some would argue, at the state level. As concepts, I would note that these principles, these values, are very comparable to the principles that are outlined in the preamble to the United States Constitution. If you remember, we the people, in order to form a more perfect union, establish justice, assure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty for ourselves and our posterity. I see many parallels in these values. They converge in principle. I thought it might be interesting to, as Shadi had done, we have some questions that have been asked in surveys to Muslims about what exactly is essential to what being a Muslim means to them. You'll note that number one is belief in God. We also see following very closely behind this love for Prophet Muhammad, that Tahira and Aziz talked about earlier, working for justice. And I would note here particularly protecting the environment ranks very highly among characteristics of what it means to be a Muslim. Following the Quran and Sunnah, we have some dietary issues, some dressing modestly, and interestingly, getting married. And when we compare this to how Christians responded to similar questions, we see that belief in God is the single most important issue for both, 86% for Christians, 85% for Muslims. Muslims ranked working for justice and equality in society third in their list at 69%. For Christians, the closest match was working to help the poor and needy, but that was only at 52%. Big difference in environmental issues. 62% of Muslims identified this as a critical aspect of faith, only 22% for Christians. So perhaps there's some work to do there. We have the importance of scripture, 59% for Muslims in terms of regular study of the Quran and Sunnah, versus 42% for Christians of studying the Bible. One point that is mentioned here for Christians is the importance of forgiveness and honesty. And I would note that those questions were not included for Muslims. And I think that that is a very serious shortcoming of this particular survey, because it leaves a false impression that forgiveness and honesty are not important to Muslims when they very much are. The Quran is filled with exhortations not only to repent, but also to forgive, and reminds us that God is the source of all forgiveness. So in terms of these values, the proper definition of Sharia, not only is there not perhaps much to fear, but these are the kinds of values that would seem to fit in very well with American society. And I think it's also important to point out that the questions that were asked here and the characteristics that are identified are all about what Muslims stand for, not what they stand against. And I think that's an important perspective that all people of faith really need to think about in an era of polarization and divisiveness, is that it's perhaps easier to think about what we're against, but we really need to think more seriously about what we are trying to build and what we want to stand for. Now, many of us coming into this may have expected that I would be talking more about Islamic law. Sharia refers to objectives and values. It's not a concrete set of rules. That elaboration of Sharia into concrete rules is what we mean properly by Islamic law, jurisprudence or fiqh. And the important difference, well, one of the important differences between the two is that Sharia is part of divine revelation, that these are values and objectives that God has provided as guidance and orientation for us, while Islamic law is really the product of human reasoning about divine revelation. And so it would be a mistake to give the two the same level of authority, because we're talking about divine on the one hand and human reasoning on the other. That also suggests to me that Sharia is something that people really need to think about and discuss and debate, so that Islamic law, as the product of human reasoning, can be subject to revision and change as human circumstances and our knowledge bases change. So otherwise stated, Islamic law is intended to be a living and dynamic process guided by this quest to uphold these values, the common good, human dignity, social justice, and the centrality of community across time and space, rather than some fixed set of regulations given once for all time. What do Muslims really think about this? Well, note here that more than half of those American Muslims who were surveyed said that they believe that more traditional understandings of Islam really are no longer sufficient for the contemporary era. And so there is a need for new interpretations to be engaged. And I think there are two realities that are implicit in that opinion. One is that times have changed, which means that the context has changed. And so the ways in which we implement these values and objectives of the Sharia also need to change. And secondly, sometimes there are developments in society, whether in our understandings of the human person or in terms of advances of science, medicine, and technology, that may require new ways of looking at traditional concepts and ideas. So to give you an example of what that looks like in practice, we've certainly had a growth of medical understanding and knowledge about the human body that has led to some changing understandings of how to live out Sharia objectives. One would be the new recognition, relatively new recognition of brain death. That formally occurred in the United States legally in 1968. In the past, Islamic legal scholars determined that a person was alive as long as their heart was beating. But as of 1986, following a statement by the Islamic Fiqh Academy of the Organization of the Islamic Conference, brain death came to be recognized such that legal death was redefined as the complete and irreversible stoppage of the heart and breathing, or the complete and irreversible stopping of all vital brain functions. So what was the driving purpose behind this decision? It had to do with the new issue of organ donation, something that was not possible in the past. And some discussion about that had to occur because there are certain organs that are required for life, and there are others that are not, such as a kidney or a portion of the liver. So for certain organs, such as the heart or lung, removing those would kill the patient. At the same time, the organ has to be removed before the person is completely dead, or it will not be usable. So having a new guideline on what constitutes death was established in order to put some parameters into place with respect to organ donations. And it was also intended to be certain that people wouldn't just be killed so that their organs could be harvested. We know that, unfortunately, there is a black market for organs today. So that's not just a theoretical concern, it's a very practical one. And I hope that gives you a constructive view of how Islamic law can be reviewed and revised in light of new information, but still guided by Sharia objectives, here the preservation of human life. So all of that said, perhaps the biggest fear factor that many people have about Islamic law is the fear that it would result in some sort of absolutist vision of what constitutes acceptable human behavior, and that it would be accompanied by harsh punishments for infractions. And that's not a surprising concern based on some of what we see in the sensational headline news. And so one of the things that I want to point out is that there are not just two categories of human behavior in Islamic law, acceptable or prohibited. There are actually 5. And that allows us to have a much broader range a view of human behaviors. So we have those things that are obligatory. You receive a reward for them if you do them, and punishment if you do not. There are things that are recommended that bring blessing because they are optional, but there's no punishment if you don't. So it's a recommendation that provides blessing, but not necessarily punishment. There are things that are permitted that do not necessarily have a reward or punishment as an implication. Those things that are discouraged, avoiding which may bring reward, definitely bring punishment if they are done, and forbidden that this is a punishment that is guaranteed both by God and possibly by society. And yet, none of these categories are really absolute. They are intended to be general guidelines, because in the case of a dire situation, the overriding guiding principle is always the preservation of human life. So you still have this underlying objective or value of the preservation of human life, and there may be times when that means doing something that you might not normally do. One case that came under discussion by Saudi scholars was whether or not it would be permissible to use a pig heart as a transplant into a Muslim patient. Under normal circumstances, pigs are considered to be unclean, and so the idea of putting that inside one's body would be problematic. However, if you know anything about medicine, the pig's heart is the closest thing to a human heart that is available. And even the Saudi scholars, who are usually looked at as the most conservative, ruled that the underlying goal of this surgery, which was the preservation of the life of the patient, overrode something that would normally not be permissible and in fact might be prohibited. And so when Prophet Muhammad said that Islam did not come to be a burden, that becomes one way of looking at things that would normally be restricted and realizing that even such things as the 5 pillars of Islam also often have exceptions to them. So fasting for the entire month of Ramadan, if you are a diabetic, which is a permanent condition, is something that is not required because of the harm that that could cause to you if your blood sugar levels are not kept at an even level. So the alternative is to feed 2 hungry people for a day so that you maintain the spirit of the fast, which is being able to connect to the poor and the less fortunate, but in a way that doesn't cause you harm. The same is also true for a woman who is pregnant or who is breastfeeding, because of the harm that that could cause to an unborn child or a nursing child if the mother was fasting and was not able to produce breast milk or provide the appropriate environment for a growing child. So I hope that helps you to think of Islamic law in a way that's not just harsh and draconian and, this is exactly the way it has to be, but it's intended to be flexible when it needs to be. It's a religion of moderation, wasatiyah, as many are fond of saying. Those 5 categories of behavior are applicable to a very wide range of issues, personal matters such as hygiene, purification, dietary prescriptions, worship regulations, ritual guidelines, modes of dress. There are public requirements, such as for criminal behavior, financial regulations, including business, commerce, banking, charity, military regulations, international law, family law, including marriage, divorce, and inheritance. When Islamic law appears as part of a country's legal code, it tends to appear most frequently in matters of family law. Sometimes it's included in criminal or commercial law, occasionally in a constitution if the country has one, possibly in a Bill of Rights. So there may be certain things that are written into legal codes, but there are various levels of policing, if you will, of Islamic law. So personal matters are oftentimes a matter of personal choice. Whether you choose to follow something or not follow something is left up to you. Sometimes there may be community support for or discouragement against a particular activity, and sometimes there are certain regulations that make it into national laws, and I think this is where most Americans have their greatest concerns, especially where criminal law is concerned. So as we're thinking about types of crime that are outlined in Islamic law, there are 3 types generally. We have hudud, which properly means boundaries or limits, so God has established these boundaries and you're not supposed to cross them. These are considered to be crimes against God that have specific punishments that are prescribed for them. There are crimes of qisas, which means reciprocity. So this would be crimes against persons, such as personal injury or homicide, that have 3 different modes of punishment. There can be some sort of corporal or capital punishment. There may be financial compensation, called diya, or forgiveness. Forgiveness is also an option. So remember I said earlier that forgiveness wasn't even included as a question in that survey, and yet here it is, right here in the legal process. And then finally we have tazir, which means discretionary punishment that's left to matters of public order or the state security. Most of our fear associated with Sharia, I believe, is connected to hudud. And so I hope what you notice I'm doing is that I started with this hugely broad topic, and we're narrowing it down and narrowing it down and narrowing it down, thinking about where the fear is coming from. So I mentioned that hudud, had is the singular form, means boundaries. And the idea here is that these are limits that God has set that we are not supposed to cross. Historically, there were 7 crimes that were classified as hudud. Theft, which one of our speakers mentioned the other day. Banditry or highway robbery, which is described as causing corruption on the earth. Today that has been expanded to include piracy and terrorism. Rebellion, unlawful sexual intercourse, slander in the form of an unproven accusation of unlawful sexual intercourse. So those 2 things have to go together, which means that if you're going to accuse somebody of having done that, then you'd better be able to prove your case, because if you can't, then you're the one who will be subject to punishment. So there's a checks and balance system that's built into this. Drinking alcohol is also listed, and according to some law schools, apostasy. Many people would agree that the first 3 in this list probably constitute very serious crimes. The last 4 are more doubtful to many Westerners today. I think the connecting factor to all of these is that they're all perceived as threats to community cohesion at different levels. Threats to property and safety, are clearly damaging to community cohesion, but so are false witnessing, the rejection of common social norms, and the disruption of family units, and even engaging in behaviors that could cause harm to other persons. So this may not be as much of an issue here where you live, but as I often explain to my college students, drunk people are not as much fun to be around as they think they are. One, they tend to be kind of loud, and they oftentimes can be kind of obnoxious, but two, when you think about the impact that alcohol has on the mind, it can lower some of the defenses and controls that you normally have in place in your own mind that would prevent you from committing certain types of behaviors. And oftentimes we find that persons who've consumed far too much alcohol may become not only aggressive, but may even become violent toward each other. So there is a certain community dimension to this. Attention to hudud often focuses on the harsh punishments that have been specified for these crimes, and what's often forgotten, even in some countries where these punishments are being revived as a sort of litmus test of their Islamicness, is that historically there were very strong requirements for evidence and witnessing that had to be followed, and the case also had to be solid. You could not have any doubt about whether or not a crime had been committed. This is the legal principle of shub. Any doubt as to whether the person knowingly and intentionally committed the crime, whether they had a free choice to commit the crime, or even if the crime had actually occurred, if there was any doubt about any of those things, you could not assign this HUD punishment. You could still assign a discretionary punishment, but not the harsher punishment. And so as one of the speakers had indicated earlier, I believe it was Jack, the court records are full of these kinds of cases where the doubt card, so to speak, is played. You know, the judge may doubt that the person who was accused of doing something actually understood what they were doing. There may be doubt on the part of the person who's accused as to whether or not what they had done fit the parameters of certain crimes. So if we think back to that example of theft that was mentioned the other day, the object stolen had to be valued above a certain minimum value. It had to be movable. It had to be non-perishable property in a protected location that would require some sort of effort and intent to steal. So if any of you ever saw the Disney film Aladdin, if you think back to that scene where Jasmine is in the marketplace and there's this kid who seems to be hungry, and so she picks up an apple and hands it to him, and then this very scary looking person says, oh, what do you think you're doing? Are you going to be able to pay for that? And she says, well, no, I don't have any money. I came here from the palace. And he grabs her by the wrist and gets ready to chop her hand. That's not how it worked. Islamic law is not about vigilantism and people going out to the marketplace and assaulting each other. First of all, food couldn't really be stolen or qualify as theft because, remember, this underlying principle of the preservation of human life. Why would a person steal food? They steal food because they were hungry, and they might need to find something to eat, and if they don't have any money, that preservation of their own life overrides someone else's protection of property. So in terms of witnesses, historically, in order for a HUD crime to be proven, you had to have 2 adult males or 1 adult male and 2 adult females as witnesses. Testimony had to be given without coercion or torture. It would be nice if certain regimes in Muslim-majority countries would remember this. Any confession given under coercion or torture is not permissible as evidence because the person was being coerced and tortured. And there are certain things that require heavier documentation. So that accusation of sexual misconduct is an important one. Instead of the usual 2 adult males, you actually need 4. And they need to be witnesses to the actual act, which, frankly raises some questions about what these people were doing and why they were watching this. And they didn't do anything to intervene. I could ask the same question about that poor woman who was assaulted on the train in Philadelphia last week with all of these bystanders. Why didn't somebody step in and intervene? So one other point is that any witness could withdraw their testimony at any time up until the implementation of the punishment. And so what I'm trying to establish here is that this system had certain built-in parameters that were supposed to provide protections to the accused by requiring very strict guidelines for witnessing and evidence. And those parameters are not always respected. Today, we could point out Pakistan and Iran as two countries where if you have a woman who makes an accusation of rape, she can actually be charged with having committed sexual misconduct based upon her confession, namely her report to the police. So we're seeing ways in which certain aspects of past systems are being re-implemented, but without the fullness of the parameters that existed historically. And there are also cases of families, and I'm citing Pakistan here in particular, who have accused women of being disobedient or rebellious toward their fathers or male relatives, not toward God. And they accuse them of sexual misconduct in order to have them jailed as a pressure tactic, trying to push them into marriage or to abandon inheritance claims or to give up certain property rights. And I've seen the same thing in a few cases in Saudi Arabia as well. So although I'm working to provide a more informed framework for understanding Sharia, I'm also upholding the fact that that's not always implemented comprehensively or the way in which the system was intended. There are very real problems in some places that should not be ignored. What gives me hope is that there are women in many of these places, including Pakistan and Iran, who are working at many different levels of society and in the government to try to bring attention to these realities, and they're working to redress these issues and put justice at the center of the matter. So paralleling back to what Shireen was talking about yesterday. You may have noticed that there was one sort of crime that might jump to mind for us that was not included as a HUD crime, and that is the crime of murder. And we think about that, God is the one who claims sovereignty as the giver and taker of life, which is infringed upon by murder. But it's because there's also this recognition that murder is a crime not just against the individual or claiming God's power, but there's also a family that is left behind. And so murder is actually considered a qisas crime, one of reciprocity. The family has a role in determining whether to ask for capital punishment, for financial compensation, or to forgive the perpetrator. And that may have an impact depending on what country a person lives in. So in Saudi Arabia, for example, this is very much part of what happens when a case is tried. And there are instances in which a family will choose to forgive the perpetrator rather than ask for punishment, because this is a way of demonstrating their faith and their confidence that God will provide justice in the afterlife, but that they want to make a different kind of statement and not cause even more disruption to the community than has already happened. So for those of you who are interested in learning more, I would just point to this book that John Esposito and I recently published on Sharia, What Everyone Needs to Know. If you're looking for more information about the role of Sharia across the full spectrum of human and community life. And in closing, as I prepare to turn the floor to my very esteemed colleague, Dr. Asifa Qureshi-Landis, I hope that what I've shared with you today has been helpful for providing a more informed framework for Sharia. And I'd also like to point out that inasmuch as there are people and organizations in this country working obviously very hard to stir up fear over a possible implementation of Islamic law as part of the American legal system, the reality remains, to my knowledge, that there is no Muslim or Muslim organization that has ever asked for that. So it's a totally artificially generated fear. In fact, in a 2016 poll that was conducted by the Institute for Social Policy and Understanding, I found that only 10% of American Muslims said that Islam should be the main source of law. 27% said a source, but not the only one. And by comparison, we have 12% of Protestants who said that Christianity should be a main source or the main source of American law, and 29% a source. I'm not really sure what Christians are referring to when they talk about Christian law, because my understanding of Christianity is that it's not intended to be a legal system. It's also not clear who would be responsible for interpreting it or according to what methodology. So there are also more Muslims than Protestants who said that religion shouldn't even be a source of the law at all. So there really is no consensus among American Muslims about implementing Sharia as any form of law in the United States. So I have to wonder if rather than stirring up fear of others, we might be further ahead to commit ourselves to ending this kind of polarization and misinformation and compete in good works and community building, which is what the Quran guides us to do, that we should compete with each other in good works. Our hope for a better future, I think, rests in people like those of you who've attended this today. You have refused to give in to hatred and fear and have responded instead with loving embrace and hospitality. And so, as you have this wonderful saying at the entrance to the university, that we all enter in a spirit of wanting to learn, and I hope that you'll be able to move forward now in a spirit of service. Thank you.
Hello, everyone. Very honored to be here. I am either the last page of a long homework assignment or the long-awaited band in a concert the feature band. You can let me know which one you think I am. All right. Like I said, very honored to be here, really enjoying the experience. I am going to connect, hopefully, inshallah, God willing, all of this to U.S. Muslims and U.S. politics right now. So what we heard, the midday presentation, was a lot about Sharia and Islam in Muslim majority lands, right? Not what goes on when Muslims are living as minorities in a non-Muslim land. And so there's a lot of, Nastana just went through a lot of the fear of, does this mean Muslims are some kind of a sleeper cell, that we don't owe any allegiance to the Constitution? And that's where a lot of the fear that she was describing is coming from. And I want to point out something really, really clear in the Sharia that is often lost on that specific topic, which is the Sharia itself tells Muslims to follow the law of the land where we live. That includes when we're living as minorities under non-Muslim rule. And this goes all the way back to before there was a Muslim government. Muslims, when they were being persecuted in Mecca, Prophet Muhammad, peace be upon him, sent them to live under the protection of a Christian king in Abyssinia. So Muslims have lived as minorities in non-Muslim societies for a long time. So we know how to do that, right? We're told to do that. The only criteria of what to do in that situation, you follow the law of the land, unless you are being forced to do something that is mandatory. Remember the 5 categories she just did. If you're being forced to do something that is mandatory in Islam, or on the contrary, if you're being forced to do something prohibited or required to do something I'm mixing this up, required to do something prohibited. So if you're being forced to drink wine, or if you are prohibited from doing something that is mandatory, so you are prohibited from prayer. In that situation, the scholars mostly said your obligation is to leave. Notice it is not to take over and change the law of the land. It is to leave, to go to a place where you are safe to practice your religion. This becomes very important in lots of moments in Muslim history. For example, the Crusades, when many generations of Muslims living under Muslim rule suddenly were under Christian and very oppressive rule in Andalusia. Luckily, in the United States, the Constitution does that for us, already protects our free exercise. So not only, as Dahlia told us yesterday, protecting no religious litmus test for the president, we also have a First Amendment that protects free exercise of religion. So we're very lucky to be in a place where that concept is built in. And it comes up in everyday life. We have lots of situations where everyday Americans are asked to accommodate for religious practices. Every year I get a note from the university reminding me that Jewish students will not be able to take exams on Saturdays and to make an accommodation for that sort of thing. So this happens all the time, from flipping the practice schedule at Fordson High School in Michigan, because almost the entire football team was Muslim and it was Ramadan and they were practicing, they practiced at night so that the football players could practice properly. And this, of course, became a big to-do. It's Islam, Sharia is coming to Michigan, Anyway, but lots of situations where people will voluntarily accommodate like that, sometimes ask for legal accommodation. What I'm going to talk about is when this shows up in case law and litigation. So I've done research on when Sharia shows up in U.S. courts, and this became a key trigger for the anti-Sharia movement. So I used to just say, here's how it shows up. It's usually in marriage cases, usually divorce cases. And then there was this, as we just heard earlier, 2010, you have this huge anti-Sharia movement that takes us, here's the topics. Those are the typical, I backed it up. The typical topics I used to say is, shows up when you're talking about whether there was a valid marriage, whether there was a valid divorce, and then this thing I'll talk about mahar in a second. Then, there's so many charts that have been thrown at you guys today. I'm going to do the same thing. 2010-ish, there started to be this movement to propose and pass legislation. This is a chart that shows you the geographic depiction. Here's a chart in numbers. Starting in 2010, you have anti-Sharia bills proposed in many states in the country, and some of them passing. So these are states that have passed what are now called foreign law bans. They started out as actually anti-Sharia bans, and we heard in Oklahoma that was struck down because Sharia was specifically listed in the bill, which is unconstitutional to target a particular religion. So of course they rewrote it to be more neutral. And so it's the foreign law ban. Here's the actual language. You can read it as I'm talking. But we've had, they've been introduced in 42 states in 2010. In 2017 alone, 13 states introduced them, and then there was a handful, I think it's like 10 or 12 that have actually passed them. So this is a law that we're talking about, where this idea that if any state court any court that I'll just read it, or decision shall violate the public policy of the state if, so it is considered to be a violation of public policy if the state the court bases its rulings in whole or in part on any law, legal code, or system that would not grant the parties affected by the ruling the same fundamental liberties, rights, privileges granted under U.S. and state constitutions, including due process, freedom of religion, etc. When this first showed up, I was like, it's just a much ado about nothing. It's not doing anything. This U.S. law already does this, right? We already have a public policy protection if anyone tries to bring in some kind of rule from somewhere else that is somehow against public policy. And so I'll tell you a little bit more about the cases that showed up. I used to think it was, when it first showed up, I was like, this is just, as Dahlia said, to get people into the voting booth for other purposes and ginning up a lot of fear, but it really wasn't changing the law on the ground in any way. I was turned out to be wrong, and I'll tell you why later. But right now I'll tell you, basically overall, the cases show, going back as far as I could research, American judges neither automatically reject Sharia-based requests, nor do they automatically give it wholesale deference. There is a complicated combination of public policy and general constitutional principles that work through these judicial deliberations. Basically, in a nutshell, American law, state law and federal law, permit courts to consider religious law to the extent that it does not violate American public policy and also state public policy, and as long as the court is not engaging in some kind of doctrinal interpretation. They're not interested in the business of telling us what Islamic law means. But when somebody makes a claim, oh, Sharia lets me do this, and that thing that they're claiming is determined by the court to violate public policy, the court will then say, I'm sorry, I cannot accommodate that religious request, unlike accommodating a request for not to take an exam on Saturday, right? So for example, child custody in family law cases, never. There's very specific gendered and age-based rules in the fiqh, in the Sharia jurisprudence on child custody that the courts unilaterally, every time this comes up, have said, no, I'm sorry, we have a best interest of the child policy, and we cannot accommodate any other version of child custody. So it never wins a child custody case. Where it usually shows up is in these kinds of, was there actually a marriage? So you're in divorce cases, the question is, were they actually married in the first place? So you have different kinds of traditions and ceremonies that various communities will decide that they're married or not. So sometimes whether or not the couple is married becomes a legal issue. Whether or not the couple was actually divorced also becomes a legal issue. There are three types of divorce in fiqh and Sharia jurisprudence. One of them is the most familiar to us, where the parties go to a third party, and it's kind of old school. You show grounds for divorce as opposed to a no contest. Like, these are the reasons for why I would like to get divorced, and it's usually the woman coming in. I'll explain why in a second. And then the judge, the qadi, will review and say, yes, according to my school. By the way, there's different schools of law that we heard earlier, and different schools will give you different grounds of divorce. But according to your school, yes, you have grounds for divorce. That's the one type, that's fasq. There's two other types that operate outside of a tribunal kind of situation, and you can already anticipate the problem. The court's trying to figure out what happened if it happened outside of a tribunal kind of adjudication. One of them is when the woman initiates it, and it happens with the consent of the husband, and they work out the details between themselves. So if there's kind of dissolution of assets or something, they're doing it on their own through mutual agreement. That one's called khul. The third one, which is probably the more famous, Muslims probably know of this one more common because it's more controversial, and that is talaq, which is the unilateral right of the husband to declare that the couple is divorced without consulting or consent of the wife under most interpretations. That raises eyebrows for courts because there's lots of situations where they want some kind of due process or a hearing involved in the decision to divorce. And so there have been some cases where the courts have had to evaluate whether that actually happened. The third category, the mahar recognition, I'll talk about in a second, but the mahar itself is a term. If there's any Jewish Americans in the audience, you might be familiar with this. It's similar in classical halakha too. There's a particular item or thing of value that is a gift that is designated in the Muslim marriage contract from the groom to the bride that is a requirement of the Muslim marriage contract. It can be very low, but there has to be some reference to it. It can also be very high. And so it is, usually it's in the contract, and it becomes, usually it's payable at the time of the marriage, or sometimes they will defer to the moment of death or divorce. So often if it's very high, it's a deterrent for the husband doing this unilateral thing, because if it's like super high, then it's going to cost him. So this is a particular thing that often is if it's high, it becomes a big issue in the dissolution of assets of the couple, because it's in the Muslim marriage contract, but is it going to be part of the division of the house assets, for example? So those are the cases that usually show up. Let me give you some examples of some cases. It's kind of checkerboard. It depends. I mean, family law is dealt with in our state court, so it depends on the state and what they do. And different state judges seem to have different skill sets about understanding what this is. And I have a little sympathy for these judges because they often are thrown with expert witnesses from both sides, and they're trying to figure this stuff out, and they don't understand it. And if you want to make a lot of money on the side, you can be an expert testament witness in these family law cases. Lots of money to be had to do this. Anyway, so there's a 1988 case. It's interesting. This is out of California, Variones versus Variones. So, what I was going to say was the cases they're checkerboard all over the place, and some do a better job of trying to understand what it is that the claimants are making, the argument, and then trying to do their best to accommodate it under American constitutional principles. But there has, so my sympathy to them is I watch them struggle and often stumble, sometimes pretty badly, at trying to really understand what this is. And it's really evidence in a lot of cases of this very confused lack of nuanced understanding of actually how Muslims live. So there's lots of cases that give you a really good sense of that. So I hope there'll be a little humor here, because I guess the Muslims might laugh along with me. So Variones versus Variones, 1988 in California. This is a situation where the couple entered into a marriage, but not in front of any kind of formal tribunal. It was done privately in a private setting. And so the court was trying to figure, and then they got divorced. The court was trying to figure out, were you married? How long were you married? And then they looked, among other things, they looked for, it was basically common law marriage, putative marriage kind of questions. Did they behave as if they were married, right? So they looked at all the kinds of indicators of this couple's life to say that whether or not they had indicated they were married, and they concluded that they didn't. And I was surprised when I saw two factors that seemed to play a significant part. One of them was that the wife kept a separate bank account. All right, so Muslim women in the room know, what are you talking about, right? It is classical, across the board, all schools of law, that a woman's property is her property under the fiqh. There is no ownership of her property by her father, by her husband, by her brother, her inheritance, her income, it is hers. And it is quite common for a woman to keep a separate bank account, just to make sure that she's got her money where she wants to and nobody else is going to use it. So that is no indication that somebody doesn't think of themselves as married. And the other thing is she kept her own name. Also, not really a Muslim historical tradition to change your last name to be your husband's last name. In fact, you have lots of people saying that's actually a thing of women becoming property of their men, and we don't do that. That's a European thing, etc. So that's a weird thing to look at, but that's a first indicator of these not quite understanding Muslims in their trying to figure out, applying simple, basic concepts in American law, but kind of stumbling. What about whether or not there was a divorce? So typically, in the cases that are really the most complex are the ones where it happened overseas. And they're trying to, typically American courts will show comity to proceedings happening overseas if there is some kind of appreciation that's like basic due process is respected in those overseas. So it's just because a divorce happened by a court in another country doesn't automatically mean that an American court isn't going to recognize it. They just kind of look into it a little bit more to make sure. So basically they're looking for things, comity usually looks at due process, notice to both parties, fairness, an opportunity for both parties to be heard, and if everyone sort of knew what was going on. So now talaq is going to be a problem, right? Because talaq can happen with a husband just saying, I divorce you, and that's it. Like, she doesn't get to contest it, there's no hearing, nothing. So what's happened is that when these talaq declarations happen in other countries, if they're done by some kind of additional proceedings required by the state itself. So if Pakistani law now requires not just a declaration, but some kind of a filing or recording or something, then it will get recognized by an American court typically, but if not, then it won't. So for example, Chaudhry versus Chaudhry, I don't have the year of this one, but this was the husband's divorce by talaq made at the Pakistani consulate in New York, so it's Pakistani territory. It was given comity because it was later confirmed that there was a proceeding in Pakistan where the wife had notice and an opportunity to be heard. So, okay, she was given fair notice. Whereas 2009 case, Tarikonda versus Pinjari, parties were married in India and moved to Michigan, and then the husband traveled to India, obtained a divorce talaq certificate in India somehow, and then the wife files for divorce in Michigan. It often happens you're having multiple filings in different places. In this case, they did not recognize the talaq because they said, according to what happened in India, the wife was not afforded basic due process, she was not present in court, and there was no hearing. So that's what happens typically. There's some cases where a concern about talaq itself as a gendered thing has now showed up in public, not now, recently, this is a 2008 case I'm going to tell you about, that the idea that talaq itself is gendered has itself triggered a public policy concern by some of the courts that look at it. Again, this depends on the state. This is a Maryland court, Aleem versus Aleem in 2008. In this case, the talaq that was allowed in Pakistan was unenforceable in Maryland because, here's the interesting, not the specific proceedings for her, but it is more abstract. Being accessible only to men and not to women, talaq itself was against public policy under the Equal Rights Amendment of the Maryland Constitution. So the whole entire concept of talaq is gendered, and so therefore never going to recognize any talaq. By definition, they said it deprives women of due process that they would be entitled to in an American court. There is some sympathy in these cases for a situation of the mutual laws that we all live under. So we have our own sort of religious code of conduct, and then we have the state law that we live under. And often you're divorced in one, but not the other. This happens, anyone on the East Coast, in New York and New Jersey, the judges deal with this all the time, of the limping marriage in the Jewish community, where the husband has absolute right to deliver a divorce, and the women are stuck. Like, I'm divorced according to civil law, but not according to Jewish law, I can't get married again. So the courts in some places seem to be sympathetic to this, and so there's some case law interesting out of Michigan where a judge looked at this, and it was the common practice for a while, and then they stopped based on this case, but recognizing that this judge was going to issue a divorce, but they asked the husband, have you given her a divorce? Have you talaqed her, right? And he refused to. He didn't want to. And the wife wanted him to say, I divorce you. She wanted to feel that she had been separated from him in the eyes of God so she could get on with her life, and he refused to do that. So while she was divorced by the Michigan court, she was not getting that. So the judge says, okay, I'm going to order additional spousal support that will continue, you have to pay her until you give her a divorce, a religious divorce. So you have to pay a little extra money, and therefore, and that's a little extra pressure to try to get it. They recognize they can't force him to give him that's a religious thing. They're not going to force him. And this apparently was sort of the practice in some of these cases. The judges sort of sympathizing with the situation of these women. In Hamoud versus Hamoud in 2012, the husband challenged this, and it went up to the Michigan Appellate Court, and they said that the Appellate Court said this is not okay to do that. And the ruling again reveals some very confused reasoning, in my opinion, about their understanding of Islamic law. So the Appellate Court of Michigan said that the court does not have the authority to compel, they recognize they can't compel the religious divorce, but they also can't do this extra spousal support thing. This, the court says the implication of the ongoing award of spousal support was for an indefinite duration and was designed by the trial court to force or pressure the defendant to give an Islamic divorce, and that is improper. Why? Because it provides an incentive for the wife to avoid ending the religious marriage. If you're confused, join me in my confusion. The court says, as structured by the trial court, plaintiff, the woman, has no incentive to become self-sufficient or to vigorously pursue an Islamic divorce, as she is assured an ongoing income ad infinitum. I'm like, hang on a second. She wants the Islamic divorce. This is just trying to help her get the Islamic divorce. She was asking for this extra spouse. The court came up with this extra spousal support to try to force it. It shows a clear misunderstanding of what it is she's asking for, right? This is the thing he has control over. She has no control over that. Remember, there's the different types of divorce, right? She could go to a third party to get on grounds of divorce, or she could get her initiated divorce, but only with his consent, right? So it's possible that she was either concerned she didn't have grounds for divorce under a third party. It was a non-contest, it was a no contest kind of situation in American law. Maybe her school didn't allow her grounds for divorce. The other thing is, oftentimes when the woman initiates, this is a matter of dispute within the schools of thought, but oftentimes when a woman initiates, she loses her mahr as a part of the analysis of the divorce. So if she initiates, so if she goes to a third party, tries to get that divorce, or she got him to consent, oftentimes giving up the mahr is kind of the way he consents. Anyway, but the way she's ensured her mahr is if he gives her a talaq. So she may not have wanted to use the third party option because she would maybe lose her money. I don't know the facts here, but the point is that, and the court seems to have been confused a little bit about this, because somewhere in the record there was this line: the plaintiff indicated that an agreement existed that would permit her brother and brother-in-law to authorize the Islamic divorce, potentially rendering it within the plaintiff's control to prolong her receipt of spousal support. So again, I think she probably could get like a third party through whatever this arrangement was that she was talking about with her brother and brother-in-law, but there are consequences to her initiating that are not consequences if he gives her a religious divorce. And so, again, the basic misunderstanding of the court is, though, the fact that she can get a third-party divorce doesn't mean that the husband can't get out of paying spousal support right now, because the unilateral is what talaq is. He wants to not pay spousal support. He can just say, I divorce you, end of story. Anyway, so that's the thing about confusion about mahr shows up a lot. And I think it's partly because it's seen through like a prism of a prenuptial agreement or something that we don't quite understand what the mahr is doing for Muslims. By the way, don't call it a prenuptial agreement if you're writing a marriage contract. That's lots of problems. Anyway, there are some cases where the court has, and by the way, this is a New Jersey case, so thank you, Dahlia, over there in New Jersey. Odatala versus Odatala, the court said, you know what, whatever the reason is that she wants this mahr, the fact, this is 2002, the fact that it comes from a religious belief shouldn't interfere with our ability to look at this as a contract, right? This is a contract, it's written down, you've got all the terms, offer acceptance, etc. So the court actually says, why should a contract for the promise to pay money be less of a contract just because it was entered into at the time of an Islamic marriage ceremony? Clearly, this court can enforce so much of a contract as is not in contravention of established law or public policy. So that works in some courts. And so usually the litigation is just over, are the terms of the contract clear? And oftentimes, unfortunately, some of these boilerplate contracts that the mosques give out are very confusing. And so some of the litigation is like, I don't understand what this means. Ring, advance, and half of husband's possessions postpone. I don't know, postpone to when, what date? It was just, but that's typical, even Islamic contract law. Clear terms is a important feature. The courts tend to seem confused sometimes. There's some cases, California, an 88 case, described the mahr as a mechanism for the wife's profiteering by divorce. Therefore, it's against public policy. So this is the case where they didn't give her mahr for that reason. It facilitates divorce or separation by providing for a settlement only in the occasion of divorce. Wondering, 2003 case, again out of California, wondering if the amount of the mahr was enough to jeopardize the marriage, so not really understanding. Now, just back up to the Islamic feminism conversation we had yesterday, there is a lot of really interesting literature, especially lately, about what is the mahr, right? Is it financial security in the event of a divorce for the wife? Is it a deterrent for the husband unilaterally divorcing her? Is it a form of compensation if you're unjustly divorced by your husband? Is it some kind of consideration, just thinking about basic contract terms for entering them? Is it simply a gift? And it's not clear because there's lots of debate over all of that. If it's a compensation for unjustified unilateral divorce by the husband, then what if the divorce is initiated by the woman? Well, then the argument of it being financial support and financial protection, why should it matter who initiates the divorce if it's just to protect her financially? If it's merely a gift, why does Islamic law treat it as a debt that is owed to her if he chooses not to pay it? If he dies or he owes debt, that if he dies, that's the first thing that's paid. So if it's just a gift, then why does it have all these extra contractual things? All of these are really good questions that happen within Muslim societies all the time. What is the role of this? How does it interact with laws about community property, no-fault divorce, etc.? Unfortunately, none of that conversation seems to be evident by the judges handling these cases. They're not aware of that. And now, even worse, back to the anti-Sharia slide. So, American judges now, I told you, they look at public policy when they're reviewing this, and usually they would go through the stuff that I just described to you. So sometimes they'd approve it, sometimes not. Now, and I said, I didn't think it was a big deal when this thing was passed. I thought it was obnoxious, but I didn't think it was going to change anything. Until this Kansas case, Soleimani versus Soleimani, where a wife's request to enforce her mahr was denied. It was denied because the court cited a Michigan case where the court had said things about the nature of talaq being gendered and unfair to women, right? So here's what the Kansas court in Soleimani 2012 says. Remember that line there about if any law or legal code that doesn't grant the parties the same due process, equality rights, right? So here's the thing. This is Kansas court talking. If the mahr agreement was the product of a legal system which is obnoxious to equal rights based on gender, a court could not become proxy to perpetuating such discrimination. So, because Sharia includes talaq, and talaq is gender unequal, therefore it qualifies as one of these foreign laws that does not preserve due process, freedom, equality for women, and therefore anything out of that Sharia, including her mahr, cannot be honored by the state court. And so this woman lost $650,000. Ironically, this law, and the court says, well, the law is passed to protect women. Sound familiar from the conversation we had earlier and yesterday about always protecting women, and we go to Afghanistan because we're protecting women? Anyway, all right. So when the bill was introduced, State Senator Susan Wagle told the Kansas legislature that it was a vote to protect women. The Kansas court, in this case, says enforcing the agreement would, if we enforced her mahr, we would abdicate the judiciary's role to protect such fundamental rights, a concern that was articulated in Senate Bill number 79. That is I don't think, if you ask Mrs. Soleimani how protected she felt after she lost $650,000, I don't think she thought that was exactly what's going on here. Even if the talaq is gendered and unfair, I don't understand why hold all of the fiqh rules hostage just because this one aspect is gender unequal. We don't do that in American law. I hope we don't do that in American law. If our voting laws are bad for women, do we also then deny them their property rights? Like, that doesn't make any sense. Maybe mahr itself is the counter to the unfair gendered nature of talaq. So why are you not enforcing the one thing that women actually have in this system to protect them? It's upside down. It's a little bit of ingrained Islamophobia. I also think it's a little bit of presumed superiority, that secular is always better. And the fact is, secular is not always better. I mentioned a few things about women's owning property. There are lots of things. I wrote for ISPU this thing about all the ways that if you looked at classical Islamic family law, it's actually better for women than certain aspects of secular law. Just begin from the position that a woman's property is her own property, and nothing happens to change that. Many Muslim women are frustrated with community property, marital property laws because it's a surprise when they find out that actually what they thought was theirs turns out not to be theirs. My own divorce, I would have come out very differently if a qadi had adjudicated my divorce. I acquired the house with my own income. I paid I earned more than my husband. I would have owned the house, and I wouldn't have had to split it. But because it was acquired during the marriage, he got half of it. right? So I was like, it's not always necessarily better to have some kind of secular law applied to your marriage, right? And so that's the thing, is that there is this presumption in the anti-Sharia movement and in general Islamophobia that Sharia is bad for women, definitionally against public policy, and anything that we do to protect women from this is good for women or good for overall rights. So the anti-Sharia advocates don't seem to think that the existing protections in our system, constitutional protections of public policy and due process, are enough. They want more, and they want to pass things like this. Motivated by some of the stuff Natana was talking about, they're worried that Sharia will take over American law. I hope we've debunked that. There is a basic rule that we follow the law of the land where we are, but also there's a concern that some kind of judicial accommodation of Muslim religious practices is somehow eroding our secular rule of law. And layered on that a lot of women, saving women thing. But I mean, I'm like, there are a lot of really interesting questions in these cases about the meaning and the scope of our free exercise clause, our establishment clause, individual rights versus religious freedom. We have a lot of interesting things that are in conflict in our society about when should all the law be the same for everybody and when should we allow people to opt out. So a lot of the rhetoric here and also in Canada with some of this stuff is like one law for all. This particular statute, this particular bill is written by this group called American Laws for American Courts, that there's some kind of uniformity as a goal, but federalism allows states to make different decisions. So there's some things in our society that we allow differences. And so slavery, at one point, we allowed the states to be different on, and then we decided, no, that's going to be the same for everybody, but we still allow states to have different rules about gambling. Depends what state you're in. So we have interesting questions about what do we all agree should be the same for everybody, and what are the things that we think are okay to let people opt out of? And the reality of religious minorities and other minorities in our country really brings up lots of really, really powerful questions about what is the role of religious law for citizens in a secular state? What kind of religious diversity do we think is good for society? Maybe even something we should enhance. And what part of it is destructive? These are really, really interesting questions, but they're not really about Sharia. They're about American constitutionalism. They're about who we are as an American secular society. And I think we really need to engage with those. And I think American Muslims have a lot to say about that. I think the LDS community has a lot to say about that. I would like to have conversations about that. Unfortunately, the anti-Sharia movement has derailed any possibility of that when it comes to Muslim cases in these family law courts. Last point, and then I'll close. After thinking about these cases for a long time, I started realizing that I was feeling more and more and more uncomfortable as I read the opinions. I was like, something is off here. And I realized it has something to do with how, even when they're trying to accommodate, how are they accommodating for Sharia and fiqh? They're getting it wrong so often, but what's going on? Why is their error so bothersome to me? And I think it's the lack of a nuanced understanding of how this would play out actually in a Muslim context. So if a qadi was doing this analysis, they wouldn't just be looking up the cases and the rules in a fiqh book and then slicing them off and then dropping them down in the cases. Qadis and muftis are required to tailor their rulings to each individual case based on the realities of the individual parties, understanding the culture, the reality, the economic concerns of each individual case. And so if the qadi was actually deciding this stuff, it wouldn't look like what it looks like when the expert witnesses are coming and saying, yep, that's the rule, that's how it goes, right? It's much more nuanced. That's not what it looks like here. There is like a hollow, like mechanical aspect to the way that the fiqh rules are depicted in American courts. It's often treated as like a static collection of legal rules that you just quote and apply regardless of context and circumstances. And I just think that that's just not how it works. That you don't just slice this off and drop it back down. So it was weird. I found myself like kind of agreeing with the anti-Sharia movement. Like, I don't want the courts doing this or not doing a very good job about it. So I don't know. I mean, well, there's lots of solutions to that. I don't have them all here now. There's a lot of things we could do. Maybe some of it is just understanding more about what Sharia means in American Muslim lives. A little bit more American Muslims going to law school, maybe. But it's a lot of education and understanding and awareness of actually what does Sharia mean in American Muslims' life every day. And I think that that is something we can all do. And this conference is a really good start to that, as many have said. And as the last speaker, I'd like to say, I think on behalf of all of us invited here, we have really, really enjoyed being a part of this conversation. And thank you so much for gathering us here. And thank you for the hospitality. And thanks to God for giving us all the ability in COVID to to gather and spend time with each other. So thank you very much.
That was a fascinating and very insightful discussion about important issues that we all face, whether in American constitutionalism or in Sharia and fiqh. Thank you so much to both Professor DeLongba and Professor Qureshi Landis. We only have about 15 minutes left for our discussion. That's okay, but we'd like to have both of our speakers come on up to the chairs here, and then we have Asma Afsaruddin, if she could come up, and also Shadi Hamid, I think, as well. We need to make sure to finish on time because we have some other activities coming up. And so I just want to go to Shadi and Asma and let you raise a question. Maybe each of you just lead off and then we'll see where it goes. Asma, would you like to start?
Sure. All right, well, I want to thank both of you for, can you hear, is that on?
Closer, I think. Yeah.
Can you hear me now? Yeah. I want to thank both of you for really excellent papers, thought-provoking ideas and insights that you shared with us. I'm going to start with you first, Natana, because you were first and you explained the basics of the Sharia really well. When it goes online, this is something I want to share with my students. It's like, I don't want to lecture about Sharia anymore. I'm going to just turn you over to Professor DeLongba. You covered the ground really, really well, very extensively. The points that you made that really struck me as being highly relevant and that you went through really, really well is that the concept of justice, right? Ultimately, legal rulings based on interpretations of the Sharia must lead to justice. But then everyone knows, of course, justice is a huge, broad term, has to be interpreted according to the historical, socio-political context in which we find ourselves in. So that in itself, just by saying that, you point to the kind of the inner malleability of Sharia, right? And the job of the interpreters, the jurists, to apply the principle of justice in very different circumstances. The second principle, I think, or the second aspect of the application of actually fiqh, I should say, Islamic jurisprudence, is that actions have consequences, particularly when they're carried out in the public sphere. So things that happen in the private domain, and you brought up apostasy, that is an extremely, I'm talking about in public, highly misunderstood concept, especially I think because of the way we use the English translation to reflect the original Arabic, ridda or irtidad, which is actually more than apostasy. If it was a private renunciation of one's faith, that usually did not have any public consequence and was not punishable. But if it was done in the public sphere and it was assumed to have implications of rebelling against the state, then that did have consequences. The jurists were required to consider that sometimes equivalent to political treason. So that distinction between the private and public domains, I think, is extremely important for us to maintain when we talk about fiqh, about Islamic jurisprudence. The third principle that you mentioned that struck me as being highly important is the preservation of life, which means that always takes priority over any other consideration, so that certain rules that we consider to be carved in stone can actually be suspended. And just think of the recent example of suspending the Hajj. The Hajj is one of the 5 pillars of Islam, but the Saudi government declared, with no opposition as far as I'm aware from the Muslim jurists all around the world, that it was going to be suspended because it would endanger the lives of the pilgrims. And that, of course, had to take priority over carrying out what's deemed to be an essential pillar of worship. And then finally, common good, another notoriously malleable concept, very hard to pin down, except in the immediate context in which we find ourselves in, right? And of course, we have those 5 basic principles: preservation of life, property, honor, family, knowledge also, akal, intellect as well as part of that. So that was a very rich discussion. And so I wanted to point out one category that didn't figure in your discussion, that of mubah, which is really neutral in the sense that there is no regulation pertaining to that particular category of action. And that opens up a lot of legal possibility and interpretive possibility, particularly for the modern period. In other words, certain things that are unprecedented from the legal point of view. In other words, there's no historical or legal precedent for these circumstances. There is actually therefore considerable leeway for modern jurists today to come up with regulations and rules that take into consideration only that new circumstance, not building on a prior juridical pronouncement. One of those things could be, and I'm actually thinking back to Shadi's earlier presentation, about governance. I was struck by the statement that you'd made that because of the nation state, and there was no conception of the nation state in the 7th century, that ideas about governance that were applicable in the pre-modern world do not apply now. I don't see a problem with that. I think many jurists would actually agree with that perception. But because governance is one of those issues that have to do with the public sphere, and could be considered to fall into the category of mubah. And in fact, a number of modern jurists have argued that way. And therefore, Muslims are free to come up with rulings concerning governance that don't violate any of these principles, that don't lead to injustice, that preserve life, the honor, dignity of human beings. And I think you emphasized that. Preserve the common good, however that may be interpreted. That might be a very useful category also to weave into our discussion of Sharia, to show there's actually quite a bit of human life and experience that continues to be open to reinterpretation or even completely new interpretations, because these are new circumstances in our lives. So based on your reading of Sharia and the legal history and the traditions that have developed, can you offer us some other examples and instances in our modern lives today that would be amenable to that kind of, not just reinterpretation, but really completely innovative ideas that could be accommodated based on our modern life?
Well, I think that you raise a really interesting question there. And what it does is it invites us to a moment of creativity and imagination. I won't say innovation, because bid'ah is such a negative term in so many circles. But I do think that we can take these basic principles and values and objectives and ask ourselves, what kind of society do we want to live in? Is there any system of government or a social structure today that anybody could look to as perfect? And if there is, frankly, I'd be curious as to what it is, because I think they all have their own challenges. And so perhaps not necessarily totally reinventing the wheel, but to ask ourselves where and how we can make improvements that would allow for all persons living in that society to enjoy those freedoms of life, protection of property, protection of security, and also to engage not just the rights, but the responsibilities that when there are those locations where persons are not living with those protections of life, property, etc., that serves as a call for reformation and for thinking imaginatively about how we might reconstruct and re-engage in order to resolve those problems. That's not particularly concrete, but I think what I'm trying to point to is, Shadi had pointed earlier to this, we have these underlying questions that have not been resolved. And I think we're in a moment where we can either fall into despair over all of the problems that we see, or we can really use this as the creative moment that it's intended to be. I think COVID has provided us with one such example. We had an incredible moment of hope in the midst of despair, we all got sent home and we had to stay away from people and essentially be locked up by ourselves. But it gave the planet a moment to breathe, that our air pollution cleaned up. There were people who were able to see the Himalaya mountains for the first time in their lives. In India, we had water sources that cleared. We had animals returning to areas and marine life where they had not been seen for decades. So perhaps what we really need to do is to be more attentive, not just to the things that we want to complain about or that we're not happy about, but realizing that we need to be more attentive to where there are positive things that are happening, and then to adjust our own behavior accordingly when we find something that is good.
Yeah, sure. So I wanted to raise a little bit of a different issue. So I think when we're talking about American Muslims tend to be pretty well integrated. I would say lower levels of, as you said, Natana, only 10% say that Sharia should be a main source of law. So in this sense, I don't want to use the word liberalized, but compared to other Muslim settings, lower levels of, let's say, strict observance, however we want to put that exactly. So I think that one can argue, I think it's also the only country in the world where a majority of Muslims support gay marriage, which is, according to a 2017 Pew poll, it used to be about 27% in 2003, and in about 10 years or so, 12 years, we see a majority of American Muslims supporting gay marriage. These are very rare things. So I'm wondering if we look at other contexts where, especially Europe, Western Europe, where we see stricter levels of religious observance, what we might call more conservative religious observance in much more secularized contexts. The good thing about America is that we are allowed to, and even encouraged sometimes, to express our religiosity publicly, and we have constitutional protections that allow us to do so. In very secular contexts in Western Europe, you have a major gap in religious observance between Muslims and non-Muslims. And I just looked back at one of the numbers. It's really so this is also Pew. So 54% of French Muslims say that religion is very important in their daily lives. For the rest of the population, it is 11%. So we have a massive, more than 40% gap in basic attitudes towards religion. So this just leads me to kind of ask, I think, a really difficult question, which is, if you are a hardcore secularist in European contexts, is it understandable to look to the Muslim minority and say, well, we're a secular society, there is a divergence here in terms of values and attitudes. We may not agree with these hardline secularists in, say, a country like France, but it's a question I wonder about. I don't always have a good answer to it. Where do we draw the line between Islamophobia and what might be called reasonable or good faith concerns about high levels of religious observance in very secularized contexts? Is there a reasonable objection to be made, especially when it comes to immigration, so on and so forth? I mean, I don't agree with this way of looking at it, but I get this question so much, and I think if we're looking at these questions objectively, I think we have to have a somewhat coherent or convincing response to that particular concern, especially as Muslims become a larger percentage of the population. So in the projections, I think that you mentioned, Natana, Sweden is an interesting case, because by 2050, with medium migration, Muslims will be 20% of Sweden and 17% of the French population. That's a pretty big percentage of the population. So anyway, yeah, this is just an open question. I think that there's different ways to answer that, but I'd be curious what you would say to people who kind of put that challenge.
Can I jump in?
Please.
I want to answer that and steal, because he was looking at you, but I'm going to steal it anyway. And connect it with your point about the nation state earlier, because I actually am working on some Islamic constitutionalism stuff that I think that a big part of the problem by Muslims and non-Muslims in this conversation is that we're all thinking in terms of a Western nation-state idea of what law is, and it actually doesn't track to what pre-modern Muslims, how they conceived of law. So even though using the word law, I don't like the phrase Sharia law because it already brings us into the English language in thinking about what law is, and it's very nation-state. And the dominant constitutional discourse today is that law is what the state does. If it's not what the state is doing, it's stuff, but it's not law. It's ethics, it's morality, it's manners, but it's not law, right? What Natana just laid out was like lots of things that we would call law, and some I talked about was like marriage and divorce law, but it's in the same books as like how do you pray and how do you treat your mom and, you know, what do you eat? Like these are not law in our sense, but they're in the same books of fiqh. So the division in pre-modern context that I want to highlight when I talk about this is I say there was two types of law in Muslim societies. It wasn't secular versus religious. It was fiqh, which is what we heard about, and siyasa, which is what the state was doing. And the basis of siyasa was not interpretation of the scripture and the stuff that Jack and who did the Quran stuff and Hadia did. That was the job of the fuqaha, giving rules of Muslim behavior. How do I dress? What do I eat? Who do I marry? Who can I leave my money to? That's all fiqh. But the state, the ruler, they would have said, the umara, the sultan, the caliph, there was a very strong moment in Muslim history where there was a big fight and they decided the state does not, the ruler does not get to decide the meaning of scripture. It was not a secular religious, it wasn't a separation of church and state, it was a separation of types of law. The types of law that the fuqaha said the state can do are a service of the maslaha that she was talking about, the public good, the general good. So the state, what we call it today the state, the ruler, was responsible, an Islamic responsibility. That's why it says not a separation of secular, that was their Islamic responsibility to keep the streets safe, to pave the roads, to make sure the weights being used in the marketplace weren't cheating each other. We would say things like building codes and health codes and all of that's siyasa, and that's a different type of law. So Muslims tend to confuse these and merge it all into the same thing. All law is one, and the problem I think with political Islamism is that they're trying to bring Sharia back, but they only use the one mechanism of state law to do it, and they're not being constitutionally creative to remember, actually, we had a whole other thing going on where the state was asked to do one thing, but it was not about interpreting scripture, enforcing scripture, and telling people how to be Muslims. And by the way, that's how other religious minorities could actually live under Muslim lands quite calmly, because it wasn't, the state wasn't set up to tell you how to be practice your religion. And so that, I think, is a piece of the answer of getting everybody to like decolonize our minds into thinking about, actually, when Muslims are talking about, when I want Sharia to be part of the system, I'm actually not talking about the state telling me how to eat, right? And I don't think that's what Muslims think. I actually was an advisor on that Pew poll, and I was upset at how they asked the question about Sharia. They changed it a little bit from my commentary, but still the way they asked it still presumed an American way of thinking about law that I think caused these kind of weird, paradoxical answers that people are trying to understand it, and it doesn't make sense. But if you know something about how law was divided before the colonial intervention, the Muslim answers make a lot of sense. So that's what I would just go back to that.
Thank you very much. Let's give them a round of applause.